If you do not resolve your case through settlement and mediation or negotiation, you will have a trial before a judge or a jury if you demanded one on time. What happens when the trial is over? The court typically says it will take the matter under advisement and make its decision at a later date. The court will mail the decision to the parties. When you get the decision, read it carefully. If you don't understand it, bring it to the clerk's office in the court you are heard in and ask for help from a court employee. The decision will tell you if the tenant has one possession, the right to stay in the apartment, or the landlord has one possession, the right to take the apartment back from the tenant through force. It also may say whether the court has decided that money is owed by either party. You may have one possession, but only be allowed to stay in your home if you make a certain payment by a certain date. Or the decision could say that you owe your landlord rent. The parties have 10 days from the date of the court's decision to file an appeal. If the court's decision is against you, the landlord has won the right to evict you. If you have not filed an appeal within 10 days, on the 11th day after the judgment, the execution is prepared by the court and available for the landlord to pick up, bring to a constable or a sheriff to serve on you. The execution is the legal document that allows the landlord to evict the tenant. The tenant can then be served right away, but must be given at least 48 hours notice prior to the forced move-out date. That's often referred to as the levy date. A sheriff may move the tenant out of the apartment and store her belongings in a storage facility chosen by the landlord.